Hello, everyone. This is Anna and Jim, and this is our second episode with live with Jim and Anna. Welcome. Happy Friday.
Nice to be here, Anna.
Yes, we've got a. Sorry about the late start, but we're here. So we've got a couple questions to discuss, and then we're going to open the floor for more follow-up questions. So keep watching, and let's see what comes out. Jim, go ahead with the first question.
Well, this is an interesting one that came in the last couple of weeks. What are the signs that I should be looking for when it comes to the financial abuse of elderly people?
Interesting question. Well, the first thing that comes to mind is I would really start paying attention to if, for example, that elderly person all of a sudden has a caregiver that pays them a very special attention, maybe spends a lot of time around. Are
you at a loss for words here?
I guess spends a lot of time around. Maybe there's unexpected extra spending that could be noticed. Help me out here.
Well, they might bring them small gifts. They might leave nice little letters for them when they're gone, or if they're off on the weekend, they might send them a card or something else like that. It would be just unusual attention that goes beyond the normal requirements of a caregiver into some sort of a personal relationship that would endear that person to the elderly person, and that becomes a problem in some cases because that elderly person may be vulnerable, the family may not be paying enough attention to them, and in some cases they ask the caregiver to help start paying their bills for them, maybe running to the drugstore to purchase things with their money, and they may have access to their purse or their pocketbook, and the caregiver may be a little slick and take some extra tips that were not intended for them.
Right, but if all of these things present, it doesn't always necessarily mean it's a bad sign, right? There might be somebody who's honest and really wants to help that person, but you got to be on the lookout if something repeats more than once.
That's add that changing caregivers every once in a while, a lot of times will bring up some people embezzling money because they're gone for a couple of weeks, and other people might have access to the bank account to see what's going in and what's going out, and would identify some unusual transactions that could be taking place. There's a lot of different things for financial abuse of the elderly. One is stealing their money. The other one, which we see that gets into the newspaper or online, is where the caregiver who might have a large age discrepancy to that elderly person ends up marrying them because they're widowed or single, and all of a sudden the estate plan changes and the caregiver gets everything, and children and grandchildren are left with no benefit after the passing of their elderly relative. So those are some of the things to be on the lookout for. I think families paying closer attention to their older relatives is probably the biggest safeguard on that. Okay?
Yes. Okay, question number 2.
I'm getting close to retirement and I haven't saved enough money. Is it okay for me to invest in riskier investments so I can make up my shortfall? What do you think about that, Anna?
I think the answer, it depends.
It depends. No, that's always your answer. But my answer is no. You shouldn't invest in riskier things to try to make up the difference, because you're exposing yourself, the word is embedded in there, to more risk, and that means you have more risk of loss, and you might end up further behind. So changing your risk tolerance to make up for a deficit is usually odds-on favorite for a disaster and having to work longer and save more. I would think a better strategy would be cut back on spending while you're still working and save more. In fact, you might even practice for the last year or two of working as living as a retiree on a reduced retiree budget and seeing how you cope with that, also offering you the opportunity to save more.
I agree. I wanted to add that if you are in this situation and it is time to retire, I think number one place would be is to look at what the lifestyle is like and if there's any room for reducing your expenses. Maybe moving in with the relatives so that you can afford the lifestyle but not have to take that extra risk with your investments.
It's tough. It's tough because you're gambling right at the end of your working days on making more money, and you may not be able to do it. And the good example of that would be people who retired around the year 2000 and the market went down 38% and their investments might have gone down 20 or 25%. That's not a good way to start off retirement.
No, that's definitely a lifestyle change, and some people couldn't cope with it.
Well, we had this, Anna, we had this question come in this morning. It says if a parent owns a 529 plan, that's the college savings plans, that there are about 70 of them out on the market. Most states have them, and then there's a number of consortiums that have come up with, even the Military Officers Association has one. If a parent owns a 529 plan, is that better than a child's, correct? And of course the answer is yes.
Yes, correct.
Why is that, Anna?
Well, when a parent owns a 529 plan and they apply for fill out a FAFSA form, it's assessed at a different rate as opposed to if the 529 plan was in child's name. So that's for that reason it's a little bit better. Still will be considered in the whole overall assessment and calculation for how much age you can qualify, but it's assessed at a much lower rate.
Well, I think the parent rate is 5% of the parental assets should be devoted to a child's college education, and 35% each year of the child's assets. How about grandparents' assets? I'm a grandparent, and I've got 529 plans. Is that hurt my grandchildren when they apply for financial aid?
That shouldn't be affecting the FAFSA application when your children are going to go apply, that year. So that's a great way to help out your grandkids.
Well, and that's one of the things that I promote. Do what I say and what I do, which is all you grandparents out there, open up 529s for grandchildren, and it doesn't count against the application for financial aid.
So Jim, are there any other ways to do something like that except 529 plans?
Well, there are all sorts of investment vehicles that you can use to save for college or any financial goal, but the retirement annuity doesn't count. But I wouldn't have anybody save a retirement annuity and then break into their retirement to pay for the college education. Better to finance it through loans than to dispose of your retirement assets because usually you don't have enough time to save them back. So it's better to be paying off the loans. And don't forget, there are different loan forgiveness programs. If children engage, the adult children who graduate from college, engage in public service jobs, then there's loan forgiveness. So there's a lot of ways to either forego loans. For example, ROTC scholarships would help you not engage in borrowing money. Going to a service academy, Navy, Air Force, Navy and Air Force, and the Army. Sorry, Army, forgot that. So there are different strategies to pay for college. Many of them require a certain length of service afterwards, though. And the same way with loan forgiveness for public service jobs, there is a time period that you have to work at, say, the Veterans Administration or the Bureau of Indian Affairs or wherever that agency might exist, and usually it's in a non-desirable area, which is why they're offering loan forgiveness.
Yeah, but I want to point out one thing, that don't get discouraged from saving in those 529 types of accounts just because you think that having an account like that will disqualify you from getting financial aid. So that's not a right mindset to think about that. Okay.
Okay.
It's just one other way to do it. So we have one more question, and then I think we're gonna open up the floor for live questions.
Okay.
For everyone who's listening. So the last question is, why do I need a will? I don't own much, and I don't even have a house. I think I would rephrase this: do I need estate planning documents such as will, power of attorney, advance healthcare directive?
Well, let's find out by stories as what happens if you don't have a will. If you die without a will, then who decides where all your property goes? Even if you don't own real property like a house, people have personal property like your bank accounts. So when you die without a will, that's called dying intestate, which is a fancy legal term for you don't have a will. But usually the state law says what happens to your property in a certain order. It might go to your parents or your siblings, or if you have children out of wedlock or something and you're a single parent. So the state law will mandate where it goes, but usually there's a probate court, or in Maryland there's an orphans court, and a judge makes the final decision on where property goes. In fact, if you die without a will, that means you don't have an appointment of an executor, and that means that judge is going to appoint the executor too. And so a judge is going to decide who manages your property after you're gone and where it goes, unless you have a beneficiary, like on a life insurance policy or a retirement account, or you own property in joint tenants with someone else where it would go to the surviving person, the joint tenant. But also, what happens if you're incapacitated? Who's going to make decisions for you? Your financial decisions come from a durable power of attorney, meaning that even if you're incapacitated or outside the United States, the power of attorney is still in effect. And also a medical power of attorney or an advanced healthcare directive, depending upon what state you're in, that details who is your agent to make medical decisions for you in case you're incapable of doing that. Those are important things to happen. And if you're old enough, you'll probably remember a case from 10 or 12 years ago in Florida with a lady named Terry Schiavo, who was brain dead because she had eaten some sort of extraordinary bad diet pills, and she was married but no documents. Her husband wanted to end the life support, and her parents filed suit to prevent that, and both the Congress and President Bush too got involved in that case, and it made headlines all over the place. If she had just filled out some documents ahead of time, it wouldn't be up to the courts to decide. Her husband, in most cases, would have had the right to withdraw the extraordinary support that was keeping her alive for 10 years. So that's a story to highlight why you want to have documents. She was 23 years old. She didn't have anything except she didn't have appointments to people to make decisions for her. So whether it's living and you're incapacitated or you've died, you need to have the proper documents. And there's multiple ways to getting them. Attorney is the best way. There are a couple of reputable online organizations. Intuit, the Quicken people have a will maker. LegalZoom is another one. and there are a couple of more out there. We usually give our clients 2 articles. Should you do it yourself? Yes. Or can you do it yourself? Yes. And should you do it yourself? No. And then we like to let the clients decide what is the appropriate way to generate their estate planning documents. Anna?
Yes, but we are big supporters of our clients having estate planning documents in place, even though some of them don't own a lot of assets or property. So estate planning documents are not only talking about wills, it's about those 2 documents that Jim described, the power of attorney for financial matters and medical form. Okay, we have one question that came in. So it reads, is it important to put REIT funds and bonds in general into an IRA, or are they okay in the taxable account as a non-correlating stabilizers? Okay. Thank you, Leo. So I guess the question is it okay to put REITs into an IRA account, REITs and bonds?
Anna, the general feeling in the financial and tax communities was to put those assets that generated income that was taxed at the ordinary rates and wasn't subject to capital gains, put those in retirement accounts, and stocks, which are subject to capital gains, and usually, as we sit here today, those are taxed for most people at a lower rate than their ordinary income tax rate, put those in the taxable accounts. It's not always the case. I think you sort of have to look at the big picture for people, but you do, on average, want to have more of the ordinarily taxed interest income or dividends. You have qualified and not qualified dividends, and that's beyond the scope of the answer to the question today.
Right.
But those that don't qualify for the capital gains rates paid on dividends, and many REITs are that way, then it would be a good place to put them in a retirement account to have asset diversification. I think that's what the non-correlating stabilizers are. But the current research shows that not only are foreign stocks and REITs becoming more highly correlated to U.S. stocks than what they were in the past. So they're not as good from a historical perspective of diversifiers that they once were. They are a little bit, but they're seeming to come closer together. And in 2008, I think we all found out that no matter what asset class you were in, they all went over Niagara Falls in the barrel. There was no escaping it. There was nowhere to hide. T-bills, real estate, REITs, even alternative investments, everything went down, and there was no place to hide, I guess, except cash. But those people that went to cash then set out part or all of the rise that came back because the market came back so quickly. You think Leo will be happy with that answer?
I think Leo would be happy. Let's see if he has a follow-up onto that, but I think that's a little more detailed. I don't see anything else come in.
Okay.
Well, our time is actually pretty much done for today. Maybe just hang out for another 30 seconds. Oh, by the way, if anybody on the line and whoever's going to be listening to this later on, Mother's Day is coming up, so I wanted to wish everybody a very, very, very happy Mother's Day.
And if you're listening to this next week, happy Father's Day.
Oh, yes, 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 yes. Happy Father's Day, too.
Can I promote my Swim with Jim interview coming up next
yes,
Wednesday?
Go for it.
I'm sorry, Monday at 9:30 with Michael Zhuang. He's Chinese by background. He's a money manager here in Maryland. He's very technically oriented, and I'm going to be talking to him about how you can be a stand-up comedian and be a money manager too, because he's also at nighttime a stand-up comedian. So it sounds like those
sounds like fun.
Two roles are conflicting. We'll find out more Monday morning at 9:30 on Swim with Jim. That'll also be archived, just like our Google Hangout Live is being archived today.
We got one question that just came in. It reads, I'm planning to marry someone who is divorced and has 2 kids. She wants her house and her other assets to go to her kids. What kind of legal documents should I look at getting before we get married? I currently have a will and healthcare directive. Well, the answer is prenuptial agreement or postnuptial agreement if you work on it after you get after you get married and everything is finalized. So I think that would be actually that would probably something that you should discuss with your estate planning attorney when you're getting your documents updated, I suppose, even after or before the marriage. I wouldn't recommend doing something like that yourself. One of those sites that Jim mentioned.
Not only that, but in most states, both parties have to be represented by different legal counsel. So that's a big deal, because your estate planning documents and any agreements that you have premarital need to be in alignment, and usually attorneys won't represent both parties because both parties have different interests. In the case of your fiance having 2 children, those are different interests. There might be some children of your marriage to her, and they would have a different status, both legally and probably should be included in joint documents that you have. And if you need a referral to a good estate planning attorney, just send an email to info@adviceonly.net, and we have attorneys that we work with all over the country because we have 5 offices, and we'll be happy to let you know of a couple of them that are qualified to meet your needs, and that they also like fee-only financial planners.
And also maybe going back to the attorney that already had created your estate planning documents, and seeing if not all attorneys do this, but if they can help you with this. If not, then we're happy to make a recommendation. I think that's it for questions. If there's more, we're happy to answer them. Send them in, maybe next time around. Or if they can't wait until next month, we're happy to answer them privately. But this has been a great experience. What do you think, Jim? We'll continue doing it?
I think it's wonderful. Did my video get on, or yeah, we've been looking at you the whole time?
Oh, it's just me. Nobody wants to see you.
Okay, thanks, Anna.
No, you were on the whole time, not to worry.
Okay, I just saw myself a little bit down in the corner, so I just wondered.
No, it's every time you spoke.
Oh, good. Well, then I'll shut up and we'll just look at you. Okay?
Okay.
Bye, everybody. Have a nice weekend.
Take care.